Mr. Hilton, before lunch you were telling us about your position on pleading and proving the claim for interest as damages. I wonder, before you return to that, I wonder if I could just clarify certain matters with you. The sums in question, sums in dispute, relate to foreign currency accounts.
Yes, madam.
Yes. And am I right to say that they were interest-bearing and that the interest would be compounded at the end of the month on them?
Yes, madam.
That's the case. And the interest that has to be calculated under the accounting exercise would be calculated in US dollars and then converted at the end of that into Jamaican dollars. Would that be right?
Yes, my lord, except for one thing which I was about to address, and that is how the 9.2 million should be treated. Because it will be my submission that that sum should be part of the accounting process up to the point where it was deducted. And it has already been accounted for after that.
Sorry, could you just repeat that? I didn't quite...
The sum of 9.2 million
Yes.
is part of the accounting process up to the point when it was deducted from the account.
Yeah.
And I take your lordships, I'm related to the evidence and submissions made by the parties below that support this. But then should be treated as having been accounted for by the judgment and payment and so on. So the answer to my Lord Hodges' question is yes, with that qualification.
Yes. So you're saying that if we were only to be concerned with Mr. Salter's grounds 1 and 2, you say that the 9.2 million and the interest which the bank has paid on that is treated as something that's complete. Is that right? And
yes,
you're not challenging it. And you're saying the only thing that has to be accounted for are the sums that were in the frozen account and the frozen account that remained in the account and the interest that is in those sums. Is that right in that?
That is correct, my lord. May I just add one thing? There is a period of time between the time when the accounts were frozen and the 9.2 was removed. So that during that period,
yes,
the accounting would assess.
So there'll be interest on what became, well, the dollar value that was in the account at that time that remained frozen before it was withdrawn. That will fall within the accounting exercise.
Yes, ma'am.
But you say it's been agreed that the 9.2 million comes out of the accounting exercise. Well, you can show us the documents that vouch that assertion anon. Secondly, it may be a related point. The bank, as we understand, has paid the 9.2 million together with simple interest at the rate of 27.3%.
Yes, madam. And indeed, there's evidence as to exactly when and how it was calculated.
Yes. And you're not appealing the fact that that's been done?
No, madam.
You're treating that as history now?
It is.
Yes. Thank you.
And you agree also, as I understand it, that the account should be carried out in US dollars?
Yes, my lord, subject to the
subject to the point.
But do you also agree that if in fact interest on the deposits in the accounts was compounded as a matter of contract, that there is a contractual claim for compounded interest, putting on one side all the semprametals, loss of use type arguments?
Yes,
you do?
Accept. Yes.
But you say now, given that the 9.2 million plus interest is not before us, you haven't appealed the Court of Appeal's decision in that regard. You say we're merely concerned with the 9.2 million until it was withdrawn, the interest on that sum, and then the interest on all the other sums that remained in the account. They are the subject matter of the accounting.
Yes, madam.
Yes, thank you.
Tell me then, if the 9.2 million was wrongfully, sorry, the 9.2 million, as I understand it, reflects a figure of, say, 361,000 US dollars. Is that right or not?
That is right. I think it's 369, but yes.
369. And if that amount should have stayed in the account, and it, sorry, you're not challenging that it was wrongfully debited. That's
Correct, madam.
right. If that amount stayed in the account, then it would have had compound interest at whatever the rate was applicable in that account.
Let me go right to that point now.
Right, okay.
Because I have said that a reconstitution of the account would normally involve treating wrongful debits as if they had never been made. But in this case, both parties proceeded in both courts below on the basis that Mr. Seaton was claiming and was to be repaid a Jamaican dollar sum.
Was claiming, sorry?
Claiming and was to be repaid a Jamaican dollar sum, not a US dollar sum.
You paid in Jamaican dollars, yes.
Yes, madam. Madam, if I could start with asking your lordships to go to page 174. 174, you will see at 173 a judgment by Justice Mangatal, an interlocutory judgment. This is a judgment in which she struck out parts of Mr. Seaton's witness statement. And on 174, paragraph 2, you will see that in his witness statement, he had claimed the Jamaican dollar $15 million sum. Her ladyship struck that out. And before I come to how Justice Sykes and the Court of Appeal dealt with that issue, if I may just summarize an aspect of the evidence, because the board may be of the impression that there was a difficulty in obtaining US dollars and that Mr. Seaton may have been maintaining a float and so on, but that's not the evidence. If you could go with me, please, to page 1768. This is part of the transcript of Mr. Seaton's evidence. And starting with the last question on that page, you will see, continuing to line 20 on the following page, you'll see that Mr. Seaton says he received Jamaican dollars that would be released to him. He would buy money, meaning US dollars, from Tom, John, Mary, Jane, and send on the local equivalent, send out to collect the local equivalent. He starts with that. Then, on page 1773, the last 6 lines, I don't keep the US. Basically, I just buy it and convert it. And finally,
1773, which line?
oh, I'm sorry.
At the bottom of the page.
Yeah, 1773, the last 6 lines.
Last 6 lines, thank you.
Yes. And then, (1776), line 16, when the judge now intervenes, Justice X, and asks him whether he can buy back the money. I can buy back foreign country from Dick, Tom, and Harry, and so on. I cite this evidence to say it is not strange that he would put his case and his claim for a Jamaican dollar sum at a higher interest rate, because there's no issue in getting the US dollars on his evidence.
No problem getting the US dollars. In your submission, there's no difficulty about getting the US
Exactly,
dollars.
yes, on his evidence. Now, at trial, counsel for the bank pointed out that Justice Mangatal had struck out those paragraphs. And at page 309, in paragraph, this is Justice Sykes' second judgment. In paragraph 8, he comments on Justice Mangatal's judgment that she had struck it out.
What page are we on now?
309, milady, I'm sorry. Paragraph 8, he observes that Justice Mangatal had made that order. In 9, he says he took a different approach. This was just a consequential order. Sorry, you can make a consequential order that the Jamaican dollar sum be paid. And in 10, you will see him commenting on the order he made. And he then stated, because there were different views.
But wasn't this Mr Seaton's witness statement as a defendant in the bank's claim? And what was being complained about was that he seemed in his witness statement to be claiming the payment back of the money, but he hadn't actually brought a counterclaim to the defence, to the bank's claim for a declaration against him, and that's why he then had to bring his own separate action claiming the money back.
Well, my lady, at this point, he had already brought his own action, so this was long after both actions were before the court. I cite these to indicate how we got to the judgments for the Jamaican dollar sum. So Justice Sykes took the position that he could give this judgment for this Jamaican dollar sum because it was merely consequential on the declaration the bank sought. Then in the Court of Appeal, at page 107, paragraph 26.
Paragraph?
26, my lord.
At 117?
107.
Oh, it's 107, I'm so sorry.
You will see that counsel from Mr. Seaton argued that the nature of the declaration sought by the bank did permit the consequential order for the payment of the 15 million Jamaican dollars. So that his submission then also maintained the claim for the Jamaican dollar sum. And he continued at 27. To deal with Justice Mangatal's order and effectively to submit. That didn't prevent the making of this payment. But I cite it, though, to indicate the consistency of the claim in Jamaican dollars. And consistent with that claim, Mr. Seaton produced and relied on Jamaican dollar interest rate data. Now, in those circumstances, an issue arose as to how the accounting would relate to an order or be affected by an order for the payment of this Jamaican dollar sum. And the Court of Appeal dealt with that issue in paragraph 51 on page 118. And perhaps I should take you to the previous paragraph, 50, so that you will see the submission the Bank's Counsel had made. So the Bank's Counsel had submitted that if you're making that award, then it should not form part of the accounting. And the Court of Appeal said in 51, they did not agree because there are aspects of the accounting that would apply to all the accounts, because there are other questions raised. And most importantly, in the middle of the paragraph, it would be on the record, at least, the sums taken from those two accounts, equating to 9.2 million, have been accounted for on the evidence and repayment ordered. And that observation that they made about there were other aspects of the accounting. If I could ask your lordships to go to 303. Page 303. One of the places where Justice Sykes' accounting order is set out.
Just before I just want to try and get it clear in my own mind. You accept, as I understand it, that the $360,000 were unlawfully debited to this account.
Yes, madam.
And I think you also accept that, therefore, that debit should be ignored.
My lord,
For the purposes, sorry. But can I roll it on a bit? And that is that if you're also then contending that that amount of money doesn't carry with it compound interest. Whereas if it had remained in the account and the debit was ignored, it would have attracted compound interest with monthly stops.
yes, I agree with that last observation.
And so, insofar as I understand it, this is an argument about how you set off that amount, the amount of the $361,000 at the end of the accounting period. You say the person taking the account should proceed on the basis that the 9.2 million is the equivalent of the $316,000.
No, my lord.
Sorry? No.
No.
Okay.
No, my submission is that because of the way the appellant put his case in the courts below, that is to claim that sum separately as a Jamaican dollar sum, secure a judgment separately for that sum at a different rate on a different basis. That sum has already been accounted for separately.
So, as I understand it, you're saying that you have accepted the Court of Appeal's order in relation to that sum.
And not appealed.
And you haven't appealed it. And therefore you have paid the 9.2 million together with the interest on a simple basis over many years, presumably.
Yes, and indeed, my lord, I have two more things to show you. One of them
But if I understand it, you say because you haven't appealed that, then unless Mr Salter succeeds in bringing in claims 3 and 4 of his 4 claims, you say we don't touch the 9.2 million and the interest you've paid. We merely look at the other sums on the account and the accounting process.
That is my assumption, madam.
Yes.
But my understanding is that the appellant has appealed that. He's appealed the concept of simple interest being paid on the 9.2 million.
Yes, well, my lord, he has not challenged the separate award and receipt of that 9.2 on a different basis.
So are you saying that it could have all been claimed and accounted for in US dollars, But in fact, how it's been dealt with is it's been converted as and regarded as 9.2 million Jamaican dollars and applying Jamaican interest rates to that. And that's sort of treated as a proxy, really, for the US aspect.
In both courts below.
In both courts below, right. So we don't need to worry about converting it backwards and forwards into dollars or what rates the dollar account would have got, because everyone's treated it as if it were a Jamaican account, accruing Jamaican dollar levels of interest.
Yes, exactly. Yeah. I mean, otherwise, the case moves from an interest rate issue to an exchange rate issue. You then get into exchange rate arbitrage, where, because later on the exchange rate moves, you then resile from your choice. But if I may just complete the things I was showing to the court. I was going, my lords, to page 303. 303 is part of the order made by the learned trial judge. And subparagraph C, whether the claimant removed any of the money standing in those accounts, and if it did, when it did this, and whether interest was paid on those accounts from which it removed the money, from the time they were frozen up to the time the monies were removed. But what the learned judge is saying is, in relation to the 9.2, for example, is that the account will be taken from the period from freezing, which I think is May 1992, to withdrawal, which is October 1992, but not after, or not necessarily after.
Withdrawals, what, 1996?
No, 1992.
1992, sorry.
1996 is a repayment of the other money.
So it was frozen between May and October 1992 and then removed.
Correct, milady. And may I just say, milady, I think we're agreed on the October. I heard my learned friend say that the freezing date was September, but I think it's October. Indeed, the chronology says October. I'm sorry.
Not the freezing date, the removal date.
No, the freezing date, milady. I'm sorry, I misspoke. The removal date is definitely October.
Yes.
October 92.
92. The freezing date is, I think, May 92. But my friend said September 91. Right. It doesn't matter from my present point.
Right.
So I said this to say that the learned judge in making his order for account made an order up to the date of removal. Now, at the time when...
But doesn't paragraph on page 302, letter A, that's not limited.
That's not limited. I agree, my lord. So,
and
A and... I'm sorry, my lord.
no, do.
So A is general. B recognizes that there are some accounts to which he later had access, those other accounts. But C is significant because of accounting to a point of removal. And that's important because it recognizes that the accounting is not meant to cover the period post-removal, because he made a separate order for that.
Is that the order in A?
C, my lady.
But
the separate order, yes, ma'am. So I'm sorry.
But fundamentally, any unlawful debit should be ignored.
That would be the general case, my lord. I can only say that this case was unusual in many respects, and this is one of them.
Yes, I think Lord Stevens must be right. In the general case, what you do is you would credit back in the sum and then into the account, and then work out an account of what the interest should have been on the account for the whole period.
Yes, I accept that would be the general rule.
But no doubt at the appropriate interest rates, contractual interest rates for a foreign currency account. But you're saying the way this was pleaded and dealt with means that the 9.2 million and the interest paid thereon were treated separately and in effect, on your submission, are no longer before us.
That is my submission. And my lord, that paragraph C of Justice Sagg's order, you had commented, your lordships had commented on there being no appeal from the Court of Appeals. There was also no appeal from this aspect of the accounting to the point of removal.
It doesn't need to if A has its effect.
Lord, I hesitate to interrupt my learned friend, but of course your lordship will, and my lady will see that paragraph C is whether the claimant removed, and the claimant in this case is Mr Seaton.
Yes.
So it says nothing whatsoever about the withdrawal, wrongful withdrawal by the bank.
Yes, that is right. That is a 1993 claim. If I may continue.
So can I just add, the accounting process is over what period are we talking about?
Yeah, so
In general, I'm not talking about the 9.2 million.
in general, from the date the accounts were first frozen,
Which is when?
which was May 1992,
Yes.
I think to judgment.
Okay.
But that
2014.
No, I think they were
14.
I hesitate to say, surely the accounting period differs depending upon the different accounts, because Mr. Seaton got access to some of the accounts in 2006. Is that right?
Yes, 1996.
1996. So the accounting should be from either 1991, which is the date that he puts forward, or May 92 for those accounts up to 1996.
My lord, I hesitated to say that.
Yeah.
Because if the accounting found that the amount that was in the account in 1996 was...
Yeah, quite right. Absolutely. Yeah.
My lord, I was...
So it should be an account up to what cut-off date do you say?
I would say judgment.
Which judgment?
To the
Judgment of the
2014
board,
judgment.
or
It could be to the judgment of the board. My submission would be to the judgment in 2014, but I could see an argument that indeed it would be up to the date of the accounting.
So the accounts have been frozen all that time.
No, no,
Frozen between 1992 and
96.
1996.
So there are no freezing after 1996.
Yeah.
But the only reason why I carried the accounting past that date is in the event that as at 1996, there was a sum that ought to have been there but was not. Then presumably that sum would continue to accrue interest. So that's the only reason why I leave that up.
with that logic, must be up to the up to the date of the judgment of the board, or up to the date of the taking of the account. In fact,
That's probably correct.
It should be, because we just don't know.
I accept that, man.
Yeah, yeah. So it's not 2014, it's not 2022. It's up to the date of the taking of the account.
I think that's correct, man. For completeness on this issue of the freezing and release, at page 289, in paragraphs 244 to 246, so Justice Sachs summarized the evidence to indicate that the sums in the various accounts had been repaid. And in 246, Mr. Seaton cannot recover all the money pleaded because he received some of it in 1996. He has not had returned to him the 361. So that the funds apart from this amount had been returned. And finally, on this issue,
Where does the judge do a conversion from US dollars 361,000 into Jamaican dollars?
one second, madam, if I may just. Okay, she said just that. Yes, my lord, the following page 290 in 247. Lordship indicates that the two sums, 369 and 9, came to $6 million short of the 15. In other words, came to 9. And then he explained the reason, which is that came from an account held by Earthgrain.
But that figure of 15 million is what the bank initially sought to recover, wasn't it?
It was, madam.
Yeah. And so they did the conversion to say that 361,000 US dollars was incorporated into that. It wasn't a conversion carried out by the court. It was a conversion carried out by the bank.
Yes, my lord. But everybody accepted it was a correct calculation. There was no issue with that being the converted value at the time.
And that would be at the dollar value as at the date of the trial, or around
Was that the date of the conversion?
At the date, but the date of the conversion would be.
Well, they thought that you owed.
In 1992. Sorry, lady.
Sorry.
In 1992, the bank thought they were owed 15 million odd Jamaican dollars. And so therefore, amongst other things, they took out of Mr. Seaton's bank account 360,000 US dollars and also 9,000 US dollars. And also took out of other bank accounts belonging to other associated companies US dollars out of their accounts as well.
That's correct, madam.
Yeah.
I see. So the 9.2 million US dollars is a conversion made as to the value of the Jamaican dollar against the US dollar back in 1992 when the sum was taken.
Yeah. Exactly, madam.
And hence you have the Jamaican interest thereafter.
Exactly, madam.
On your approach. Yes.
And but the Jamaican interest on your approach is simple interest.
It is, madam. I just make an observation, my lord. The Appellant's case has a footnote 3 on page 1990. Which observes that in 1992, the Jamaican dollar was worth 2 pence British, and is now worth less than half a penny.
Yes.
Sorry, where is that? Sorry, that's...
Footnote 3 on page 1990. So the footnote is right, except that the reference to 72 million should be 72,000. I think that's just a typo. And that is why, of course, this issue is so significant. Quite apart from any interest rate issue. If you converted it, then accepted the conversion, claimed the Jamaican dollar, threw out both courts, successfully recovered it, can you, because of the changes in exchange rate, can you now go back and say it should be at the original? I was about to show Your Lordship one last bit of evidence, if I may. at page 2558 of the bundle. And I trust your lordship there's an addition fairly late in the day to the electronic bundle.
No, my bundle doesn't go up to.
We don't have a 2558. Our bundle stops at 2538.
If I may just inquire, my lord. My lord, 2 days ago, we filed a supplemental bundle with two sets of documents that I was told would be in the electronic bundle.
I think I remember seeing the email, and I think it was meant to be put into the bundle. Just bear with me. 2 days ago.
On Tuesday, yes, ma'am. And there was a letter from a friend solicitors objecting. I don't know if they are maintaining the objection, but I can explain why we think they should be before the court.
Managing to find it in my bundle at the moment. I don't know if anyone else is.
I have no recollection.
Or an
Anyway, if you give us the page number and tell us what you're looking at, I don't wish to detain.
But let me indicate first, my lord, what this bundle contains, and then I'll take it to it's two things. The first is it contains the rates that the bank's counsel submitted to Justice Sachs. So that Justice Sachs, in his judgment, mentioned that the bank submitted rates. These were US dollar rates. And the reason why we found it necessary to put it in, there was no issue in the Court of Appeal that these rates had been supplied. But in my friend's written case, there is a statement that the bank did not supply any such rates. Hence, we thought the importance of putting in the actual document. And the other thing is the exchange of correspondence between attorneys for Mr. Seaton and the bank, while the matter was before the Court of Appeal and after, with the payment of the judgment and of another sum in relation to the frozen accounts. So that my lady Rose had asked earlier if we knew exactly when the payments were made. These documents indicate exactly when. But as my Lord Hodges said, to not delay, I'll just tell you the page numbers and what they show, if I may. There's importantly a letter at page 2562 from Mr. Seaton's attorneys claiming the balance on the Jamaican dollar debt, claiming it in Jamaican dollars, attaching a calculation of it in Jamaican dollars at the 27.3. And that sum was then paid on March 28 in Jamaican dollars. It also shows for completeness at page 2560. I'm sorry, 2558, I'm sorry. A payment in US dollars of a sum in relation to the interest on the frozen accounts. That was in US dollars. The judgment debt was in Jamaican dollars.
Just bear with me. I've been told that we can now recover the documents in our share folder.
No. Not yet.
It's not there yet. Yeah, time is short. Just continue. We can check these documents later.
I'll move on, if I may, Madam.
So is what you're saying is that this whole accounting to look into what the interest rate would have been on the US dollar account is irrelevant because the sum was being paid back in Jamaican dollars with interest at Jamaican dollar rates, even though, in fact, it would have earned interest at different contractual rates because the sum was actually in US dollars. Is that what you're saying?
No, lady.
No.
Because,
I don't understand.
of course, there were 5 accounts. So there were other accounts and other
Yes, but just looking at the, looking at the 9.2 million.
Yes. In relation to the 9.2, it is only relevant to the extent of the period prior to the 9.2 being taken out.
The accounting is.
The accounting, yes.
Right, but as far as interest on the 9.2 million,
It would not be relevant.
well, just let me finish. On the 9.2 million, I thought what we were looking at was that part of the accounting exercise would be to work out what that sum would have earned in the account that it was in, or an equivalent foreign deposit account, over the period between the money being taken out and the money being paid back. But that would have been a dollar account, and the interest rate, the contractual interest rate, would have been appropriate to a sum of money in dollars. Whereas now what I think I understand you saying is that because that sum has always been treated as 9.2 million Jamaican dollars, it would be apples and pears to then apply to that an interest rate charged on an account or given, paid in an account in US dollars. One has to look at some interest rate paid on an account of Jamaican dollars, and that's already been paid, you say?
Yes, my lady.
Except it hasn't. I mean,
Well,
Mr. Salter's point is that what has been done is an unprincipled charging of simple interest on the Jamaican dollar rate.
But then how does one get to what is an appropriate interest rate if the interest rate, in fact, on the account in which the money was would have been an interest rate appropriate for a deposit in dollars, but this is now not being treated as a debt in dollars, US dollars, it's being treated as a debt in Jamaican dollars?
Well, if I may answer your lordship.
Yes.
If your lordship and my lords are not with me on my submission that the 9.2 should be treated as being accounted for separately by way of the judgment, and that it should be treated as not having been deducted in the first place. It should form part of the accounting. Then the rate of interest would be the contractual rate, compounded.
Yes. Have I correctly understood that your submission really hinges on whether or not the issue is now closed? Because, as I understand your submission, it's been dealt with on a Jamaican dollar basis, it's been calculated, the money has been paid, and the money's been accepted. And that issue is no longer before the court.
That is my submission, my lord.
But if you're wrong about that, then it unravels all the way back, and one has to have potentially a new account carried out for the whole period in US dollars on a compounded basis.
Yes, accept that, my lord.
Yeah.
And if that's the case, and if the Mr. Seaton's only claim were for the contractual interest, if for the reasons you've submitted he does not have a claim of interest as damages on top of that, then the outcome of the accounting would reveal a US dollar figure to be payable, which is a combination of the principal sum and interest. And as to whether the bank had to pay any more, we would have to compare that sum with the sum that has already been paid by the bank.
Yes, I accept that, madam.
And your position would be protected if you used the conversion rate when you're doing that set-off at the end of the accounting period. If for part of the money which is found due on taking of the account, you use the set-off, the conversion rate, the monetary conversion rate, that was applicable at the time that the 9.2 million was paid.
Yes, if you use the same exchange rate.
Exchange rate for that aspect of the claim. You then use the current exchange rate for any other money that's due. Your position, they wanted to make their claim in Jamaican dollars. They got Jamaican dollars at the applicable conversion rate at that time, the time that it was paid. Okay? And well, it wasn't paid actually, anyway. But the conversion rate, if you do the account in US dollars, and at the end of that account, some money is due from the bank to Mr. Seaton, which is the conversion rate to be applied, the conversion rate at the end of that account?
I think, my lord, the consequence would be that there would be a US dollar sum due today, and one would need to use the conversion rate today.
Yeah.
But is what you're saying that at this new in this new bundle, which has now appeared in our things, that there was a demand at 2562. Oh, sorry,
That's correct, ma'am.
2562.
Do you have such a page?
Well, you have, it's page 30 of 33, but it's, the number is at the bottom of
Well, I haven't.
Just come in now.
It's come in an email, is it?
Yes, and no, it's been put into our file, into our folder.
It wasn't a minute ago, but maybe it is
So
now.
it's just come in
Right.
into the Supreme Court folder.
Okay.
May I take you to the sequence of these documents? Hello?
Yes, please.
So that 2560 reflects a Jamaican dollar payment of $46 million. It refers to a spreadsheet, which is at page 2564. It's not the one that follows it immediately. That explains how the 46 is arrived at. That's March 22nd. And you'll see that it gives credit for a payment of 29.
I do beg your pardon, which page are you on now?
So,
Well, that's 32 for us.
so 2564 is a spreadsheet referred to on 2560. And you'll see that it calculates a total of 75 million.
So who is putting forward this calculation to who?
Bank's lawyer,
Sorry?
the bank's counsel.
Bank's counsel is proposing this as what they're prepared to pay.
Yes, my lady. And Mr. Seaton's counsel replies on 2562 to take issue with one aspect of the calculation, and that is the credit for the 29, which they say the 29 relates to something else, relates to the frozen accounts, not to the 9.2. And therefore, the full amount of 75 should be paid, i.e. pay the 29 again.
Is that 75, is that also Jamaican dollars or is that US dollars?
Jamaican dollars, maybe.
But this is all subject to the Mr. Seaton wishing to appeal against simple interest.
Yes, but not against, my lord, the Jamaican dollar sum he claimed and received.
Lord, I'm sorry. We really do object to this bundle, which came in without any prior notice or any prior warning to us 2 days ago. You are being taken through a edited selection of the correspondence, not the full correspondence of the time. I am instructed that letters which are not before your lordships make it clear that these sums were accepted only subject to the appeal to your lordships and my lady, and that it is wholly improper, I regret to say, to give such a partial account to this committee.
Thank you. Mr. Hilton, it does seem to me that these documents have been lodged late without the agreement of the appellants. And if they are not a complete picture, then I'm not sure how much weight we can attach to them at all. Given the nature of the appellant's appeal, where a root and branch attack is made on the logic of the award of simple interest at 27.3%, unless you were able to demonstrate that the appellant had barred himself from making that challenge, then I think we have to revert to basic principle. The basic principle is that the appellant is entitled to be put in the position he would have been in had there not been a breach of contract. And prima facie, that involves reconstituting the account as if the money had never been withdrawn, and working out what would be the contractual rate of interest over the period that the money was not available to the appellant. And I don't see at the moment how you can argue that the payment of the 9.2 million Jamaican dollars together with interest is a matter that is closed to this court. I mean, why do you say they are barred from running the appeal which they're running?
My lord, I can take it no further, that particular issue, only on the basis that I've already indicated, the way they made the claim and the orders made. I can take it no further.
In fairness to yourself, it wasn't, as far as I can recollect, put into your written case.
That is correct.
Yeah. So it's a new oral point being made now.
And the case is dated after the latest correspondence you're showing us.
Pardon me?
The case is dated after the latest correspondence you're showing us.
Yes. My lords, while we're on the supplemental bundle, may I just inquire whether my friend, this bundle contains two things. One is those letters that I've just shown you, and the other is the submission in the court below with the other rates. May I just inquire whether my friend...
Well, I think I can't see any objection to us seeing a document which was from the courts below.
Lord, I hesitated to make any objection to this, I regret to say, because it depended the use to which it was made. But if the use to be made is misleading, then I have to object. If, on the other hand, these are submissions that were put in below, then unless I'm prejudiced because I can't show your lordship our submissions on that, I don't think I am, having read these.
No.
We don't take no point on it.
So which page would you like us to look at, Mr. Hilton?
I was not going to do it, no, my lord. I just wanted to ensure. But at page 2541, starting at paragraph 14, counsel refers to the claim and then goes on to provide Bank of Jamaica interest rates on foreign currency deposits for the period 1996 to 2011.
So these are submissions made by the respondents, is that made by the bank?
By the bank, yes.
By the bank, saying that Mr Seaton is limited to the deposit rates on the foreign currency for the relevant period.
Yes, madam. And what
Sorry.
may I continue?
Yeah.
Yes. So what your lordships will find, and I'll show you in a moment, is that when Justice Sykes was dealing in his second judgment, so that in his first judgment, he invited the parties to submit rates. Both sides did. In his second judgment, when he was addressing the question of the accounting, he did not mention this at all. He only mentioned justice, the appellants' rates that led to the 27.3%. He mentions this when he came to deal with indemnity costs. And he mentions this only in the context of the bank sent this in late, meaning not during earlier negotiations. So that the learned judge ignored the foreign currency deposit rates and chose instead Jamaican dollar lending rates.
Those are, as I understand it, foreign currency deposit rates as recommended by the government, which bear no reality to the foreign currency deposit rates actually paid by commercial organizations.
No. These are average rates. So both parties provided average rates. So the Bank of Jamaica publishes average rates charged, offered or charged by commercial banks.
For the period.
Yes.
And they do period for the year.
Yes, and they have different rates for different currencies and for different types of lending or deposits.
May I ask, if you're wrong on the submissions that you've made to us up till now, you're not inviting us to make a finding about the particular rates that would be available on a foreign currency deposit account. That would all be left to the further account, would it not?
Yeah. So what I'm about to do, is to go on to the question of the appropriate interest rates for the accounting.
Yes, thank you.
Right.
And that submission, if I may go to that, is that appropriate rate should be the contractual rate, which the registrar should be left to find.
I mean, would the bank have records of its contractual rates for US dollar accounts going throughout the period? Presumably they would.
Yeah. The difficulty, my lord, in this case is that there's been reference to successor bank. This is it. The original bank failed. Many years later, a new bank that had acquired the portfolio was then defending the case. There was a huge shortage of documentation. And this is why the evidence was so limited.
I see. So, but would you be content if this exercise were done, if the registrar looked to the, as the best evidence, the average rate on foreign currency accounts denominated in US dollars in Jamaica at the time, insofar as the evidence of the rates applied by the failed bank are not available to you?
Well, first of all, my lord, I don't think the registrar will need to go there.
Right.
First, because this dispute started in May 92 or perhaps September 91. The evidence includes the bank statements for many months prior to that, when there was no dispute. Now, if I could give your lordships one example.
The interest rates for a period prior to the dispute, I'm not sure those are terribly helpful, are they?
Yes, except my lady, they would show if one wants to find average rates, you can show the rates that the bank was paying over the period of time right up to the freezing when there was no dispute.
And what rate were they paying?
Pardon?
What rate were they paying?
5.5, 5.6.
Right.
And how does that compare to the average rate at that time?
As from the Bank of Jamaica?
Yeah.
I don't know, my lord, because the evidence...
Because I mean, if the bank was paying at or close to the average rate at the time, then insofar as there are no records, the average rate would be a reasonable proxy for fixing the contractual rate.
Yes. Well, I say two things for that, my lord. The starting point is, of course, contractual rate. And if one can tell what was the rate paid by the bank in the months preceding the dispute, I would submit that that would be the best guidance.
But it would change over time. I mean, we look at page 2542. In 1996, the average rate was 9%. In 2010, it was 2.44%. The fact is, the rates will have changed over time. We can't take a moment of time in 1992 and say, well, that's the rate that's going to apply throughout.
I agree, my lord.
So, I mean, we don't obviously know the extent of the lack of evidence, but that's why I say that if evidence which the defendant bank should have had isn't available, if it can be shown to the registrar that the bank in question was tracking fairly closely the average rates in Jamaica, then would it not be an appropriate tool as a surrogate for the contractual rate to take the average rates?
I think that would be right, madam. Because if one cannot ascertain the contractual rate over the period, one would have to...
I think we're going to take us to one example, will you, of...
I was not...
Yeah.
So...
See if we can get anything from it. Maybe we can't.
At page 552...
552.
You will see the bank statement dated January 31, 1991.
This is back in the big bundles.
Yeah.
Yes.
Yes, my lord, my lady. Now, that statement shows a closing balance of $2,086.79.
So this would be a rate of about 5%, or just this would be a rate of just a little bit under 5%.
A little over, man.
A little bit more. Okay.
But the difficulty with that is that at page 483, paragraph 53, the claimant, Mr Seaton, says that the bank was at all material times obligated to pay interest on the said accounts at the rate of interest prevailing in respect to the period of the deposit. So he was saying it's a variable interest rate, whatever's prevailing at the time. And that is common sense.
And well, I have to take, of course, Lord Bridges' point that over the years,
Yeah, it changed.
it certainly changed, yes.
So one's seeking to find the bank's prevailing rate. That's an impossible task because of the lack of documentation. And then one goes to prevailing or average rate in banks in general in Jamaica over that period.
Indeed, my lord, since the accounting will take us to a point after the bank closed, the bank would not have had a prevailing rate.
Sorry, was that?
Since the accounting period
Yes.
may take us past the point where the bank closed, the bank would not have had a prevailing rate.
Indeed, indeed.
Of course.
Yeah.
But you've got to have a contractually agreed rate of interest, either expressly or you think impliedly. So the normal implications for how one works out that rate of interest, wouldn't they?
Yes, would be based on the market at the time, yeah. But we then would need to add two qualifications, perhaps. Those conventional average rates, I would submit, ought to be foreign currency rates and deposit rates, or rates on foreign currency deposits, put more accurately.
Because that's the nature of the account.
Exactly, madam. And I accept compounded.
I was just looking at 552. Is it about 6%? Just under 6%, is it?
I actually, our calculation, my lord, is exactly 5.5%.
Okay. And I'm just looking back at the figures you gave us on page 10 of the supplementary bundle. We can see that in 1996, they'd risen to 9%. And then it appears that over time they fell back down to below 5%. So it looks as if between, well, in the years leading up to 1996, the interest rate rose up from somewhere between 5 and 6% up to 9% before starting to fall back.
That is correct.
And that might make quite a difference over a compounded.
Over an extended period. I agree.
But you are accepting the rest periods are 1 month, monthly,
Yes, madam.
and compound.
I am, madam.
So,
In the accounting.
sorry?
In the accounting.
Yeah.
Yes.
So we're purely talking about the rate.
Yes, my lord.
Yeah.
My lords, our written case also addresses the alternate situation and the alternative argument by my learned friend. If your lordships had determined that the 9.2 should be treated separately and at that higher rate, my friend was arguing that it ought to be compounded. In the submissions I made at the start in relation to the effect of the Semprus judgment on the need to plead and prove, it would be, I'd rely on those submissions to say that if that was to be treated separately, it ought to be simple interest, because that would then be an award under the statutory power. But setting that aside, if it is taken into the accounting, that issue then does not arise. So I just mentioned that for completeness.
And have the parties agreed that the accounting be carried out by an independent person as opposed to the registrar? Because I was just thinking in terms of the order to be made by the board. Because there's no appeal against the account, the account's going to take place.
My lord, there were discussions in that direction. There was not a final agreement. I don't know whether, it seems to me to be an eminently sensible course to take. And perhaps the parties can have a discussion.
Okay.
But as of right now, there's no agreement.
Well, it partly depends on what the nature of the exercise of the registrar is going to be. If there's going to be a lot of evidence about different interest rates, that's a different exercise from saying to a registrar, this is a sort of number crunching exercise, these are the sums of money, these are the interest rates you need to apply over these times, just please work out the arithmetic. That's one exercise, but an exercise to decide on the basis of evidence what the correct interest rate should be, I don't know whether that's an appropriate exercise for a registrar to take it, to undertake.
Well, I suspect...
You know, there might be very substantial sums of money depending on the answers to these things.
I suspect still be more a number crunching exercise, because there's really just one source of the data, of the interest rate data. But I mean, I take a leadership's point that the nature of the accounting would affect who would be the appropriate person. But
that raises the spectre of remitting that issue to the trial judge. and also directing an account after he's decided it.
What issue, my lord? I'm sorry.
Well, the issue is what the rate should be. The judge can direct the registrar to take an account on the basis of certain factors, and it might be more appropriate for the judge to decide what the rate should be, as opposed to the registrar, because presumably the judge has the ability to call for evidence to be given and for subpoenas to be issued and so on.
Well, except, my lord, if the board were to indicate that the rates should have these qualities, this is the nature of the rate, then the registrar could do it just as well as the judge.
Yes, I mean, if we were to indicate that insofar as there was evidence of the bank's contractual rate, that evidence was to be, that rate was to be applied, if for the reasons that you've explained evidence has been lost, we were to direct the registrar to have regard to the Bank of Jamaica's average rates on foreign currency deposit accounts denominated in US dollars. And would the Bank of Jamaica have those figures?
They do, madam. They go back to 2017.
These ones you just talk about foreign currency weighted deposits. They don't. The figures you've given us aren't necessarily US dollars, are they?
I'm not sure, my lord, whether they have US dollars separate from other foreign currencies. They may have just one foreign currency rate.
But if we were to specify a proxy for the contractual rate, then the registrar could carry out the mathematical exercise.
I see no difficulty in that, madam. And indeed, neither the trial judge nor any of the parties, I think, saw any difficulty in that exercise.
But just to confirm in my own mind, you would accept that whatever rate that turns out being, whether it's the actual rate or a proxy rate, as my lord says, that would be on the basis that it's compounded monthly.
Yes, ma'am.
Yeah.
Are we setting an impossible task for the registrar in the sense that do the banks still have bank statements for these accounts, all 5 accounts, covering this period?
My understanding, my lord, is that there was no documentation available other than what was in evidence.
And so there's, as soon as they freeze the accounts, they didn't send out any bank statements to Mr. Seaton.
No, there are statements going past the freezing.
Went past the freezing. And when did they stop?
I think 1996.
End of 1996.
And that was when that money was withdrawn.
Correct.
Other than what we've been describing as the 9.2 million.
Correct. So all the accounts were closed at that time.
So we've got accounts for the whole period of the frozen funds to 1996, and in relation to the dollar equivalent of the 9.2 million, we merely need to apply to that the interest rates either known to be contractual or determined as the proxy of the contract rate.
My lord, there are, if I may just correct something, there are actually statements to 1999, but not on all accounts. So in the record, you see page 848.
840.
848. Indeed, it appears that there are statements at 849 at 2000.
Well, lady, the easiest place to find where the statements are rather than going through them individually is to look at the documents at the opening pages of the bundle, the index, because on page 7, for example, bank account statements for account ending in 579 goes on to page 10, and ends on the 31st of March 1999. The account ending 024 goes on right the way through the pages until page 14, ends on the 31st of March 1999. For the account ending at 809, we've only got 91 to 96. The account ending 561, we've got 1990 to 1993. 1992, sorry. For 172, we've got 1991 through, if we go to end of page 18, 31st of March 1999. And it's the easiest place to see what statements are available because they're listed there.
Thank you.
Thank you. Ahmed, Dodson, Leader, unless I can assist the court further.
Thank you very much, Mr. Hilton. Mr. Salter.
May I begin with a short list of the points that my learned friend has made, which we simply cannot accept. The first one is his submission that there was no difficulty obtaining United States dollars at the material time. Of course, that flies in the face of an unappealed finding of fact by Mr. Justice Sykes, paragraph 21 of his judgment at page 210, to which I previously invited the attention of the board. The learned friend took the board to various items of the transcript. This, unfortunately, runs the risk, when one's dealing with the transcript of an extremely long trial, of taking aspects of it out of context. Those comments were, as the board will see if they look at can be bothered to look at the transcript at any length, were in the context, of course, of the Prolacto deal and how the Prolacto deal was being financed by Mr. Seaton. But just as a matter of common sense, if there had not been, as Mr. Justice Sykes found, an acute shortage of Jamaican of foreign currency in Jamaica at the material time, there would have been no need for the involvement of Mr. Seaton to provide the foreign currency for the Jamaica Commodity Trading Company, the government institution. It hadn't got the foreign exchange. It needed someone who had, Mr. Seaton. And to take one or two comments of that context, especially the comment about old Tom, Dick or Harry, I would have found someone. It doesn't say at what rate or anything like that. But I come back to the point, my lord, this is an unappealed finding of fact by the first instance judge. There isn't time, I regret to say, to take your lordships through the transcripts to demonstrate that it's not the point. The second point, that we've somehow accepted the sum in Jamaican dollars. Your lordships, my lady, have my point on that, the extract from the correspondence that you've been shown is partial. And we have done no such thing, that our acceptance of the money, to which we're entitled under a judgment, is nevertheless subject to our right of appeal against the judgment which we were objecting to on the basis that put forward in our grounds of appeal and in our case.
I don't think it's being seriously asserted that you're stopped from pursuing your appeal.
I'm obliged. I will take the matter no further. Lord, the third matter that we don't accept is the rates of interest and the like put forward by my learned friend. I did invite the board's attention to page 340, but can I do it again? My learned friend is right in saying that this discussion is not in relation to the accounting, but in relation to the question of indemnity costs. But the reason it's in relation to indemnity costs is it's part of the learned first instance judge's criticism of the bank's conduct in failing to put forward any proper records to explain what was being done generally to deal with these matters. And can I invite the board just to read paragraphs 67 and 68, and perhaps 69 as well. And perhaps also paragraph 73 at the bottom of page 341 and over to 342.
Are you content that if there is no evidence as to the actual rate that the bank would have given on the accounts, that it should be the prevailing average rate as applied by Jamaican banks in Jamaica?
Lord, with regard to head 2 of the loss claim,
Clearly.
absolutely.
Yeah.
Because, of course, my lords, that would be a rate payable by the bank on deposits. So it would be the deposit rate.
Yeah.
Of course, what we are claiming under heads 3 and 4 would be the borrowing rate, which would be significantly higher. Well, Lords, the rates, we haven't got the bank's rates, but the rates are published by the National Development Bank and by the Bank of Jamaica. One will be able to get those historically for US dollar accounts, we apprehend, without much difficulty.
To the National Development Bank
Yes, my Lord.
and the Bank of Jamaica.
And the Bank of Jamaica, all of them will have rates which would show what the market rate for and in the absence of evidence from the bank, that's the best we're going to do. And as the learned judge said, if the bank had come forward with those rates at an earlier stage when Mr Seaton was seeking his accounting, it might be that a lot of the angst in the case could have been avoided. But they didn't, and it's now nearly 30 years ago. The fourth point that we don't accept is that there's any proper argument that can be made on the difference between jurisdictions and the practices in the United Kingdom are different to the practices in Jamaica. That may or may not be the case in particular areas of the law, but I'm not inviting the board to substitute its own UK view of what happened. I'm inviting the board to uphold the decision of a first instance judge in Jamaica, an experienced Jamaican judge who is well aware of what the practices in his own jurisdiction are. And that brings me to another point, which is that the issue for the board in relation to the decision on compound interest and the like is not ultimately, we submit, a question of whether this board would have made that decision, but whether the decision of Mr. Justice Sykes was so wrong that the Court of Appeal of Jamaica was entitled to set it aside. Because after all, the decision as to whether the pleadings are adequate, whether the evidence sufficiently establishes the case, is preeminently a matter for the first instance judge, who is seized of the case as a whole and has heard it over a prolonged period. Appellate courts are, of course, not prohibited from interfering, and particularly in cases like this, which depend upon the law. It's not a question of having seen and heard the witnesses. It is, on the other hand, one of those matters in which
I just cannot understand how you can direct a registrar to apply a Jamaican rate of interest to a dollar account. How that could possibly be pragmatic.
My lords, my lady, I've tried to be as realistic about that as I can be, shall we say. It was done, I suspect, because of the confusion. And the confusion is comparatively easy to understand. This litigation begins with the Bank of Jamaica, the bank here, helping itself to Mr. Seaton's money to recoup what it apprehended was an amount due to it because it had paid a larger amount out in Jamaican dollars. There's one point at which the judge says it didn't seem to be terribly concerned about whether it was entitled to do it or not. And it brought an action seeking a declaration that it had done it. The learned judge says at various points in his evidence that it's not wholly clear from which accounts the money was taken. We can just about piece it together because you can see the evidence in the bank statements. But Mr. Senior, who was the bank's witness, wasn't really very positive about it. And at one point, the learned judge says, well, I'm relying upon the admission in the pleadings by the bank that it had taken the 15 million. Apart from that, it's not entirely clear how it got the money. And so you start with the bank's admission as the evidence of what's gone, as it were. And therefore, there was a concentration on Mr. Seaton's case in saying, well, you tell me you've taken this money, give it to me back. And the learned judge looks at it and says, wrongly the Court of Appeal found, and we've not sought to appeal that finding, that he wasn't entitled to claim it in the bank's case because he, for reasons which obviously seemed good to the counsel then representing him, not put in a counterclaim in the bank's action. But he had brought his own claim, and I've shown the board the statement of claim in his own claim, and that quite clearly claims the sums in the account in the currencies in which those accounts were there. And that was his claim. And that's the one on which he got judgment. And it's unfortunate, perhaps, that the learned judge got confused between the Jamaican dollar sums and the sums which Mr. Seaton was actually claiming back. And our submission that he tried to impermissibly ride two horses, if you like. The accounting claim, which will reconstitute the accounts as they were, and then the bank's claimed a declaration that it was entitled to debit X Jamaican dollars from the accounts. Well, if it says it's taken that, I'll make it give it back. In truth, there's an element of double counting in that, which is why I've put at the forefront of my submissions before the board today the idea that the accounting claim will actually put things right, because the accounting claim, if done properly, will simply reconstitute the accounts without what's gone wrong. That brings me on to the cases. First of all, the Abli-Azov case, to which the board invited my attention this morning, and then the F&T Terrix case, which I was handed as I was sitting down listening to my learned friend in the later part of the morning. They're both first instance decisions. They're both cases which involve very different facts. Abli-Azov was a complicated fraud on a Russian bank. And what Mr. Justice Tier did in the circumstances of that case was to go through the specific pleadings that he'd got, which I know from the involvement of those sitting behind me were much longer and more complicated and much less rough and ready than the pleadings which were characteristics of Jamaican pleadings, shall we say. The board can take judicial notice, if only from the list of heavyweight silks at the front of the case, that they were complicated pleadings, and he goes through them fairly carefully. And as the board will see, the pleadings are claiming compound interest under the equitable jurisdiction. For example, in the Granton action, the prayer claimed interest in all sums at the rate of 8% compound with quarterly breaks, or simple interest pursuant to 35A and or the equitable jurisdiction of the course and or Section 44 of the Administration of Justice Act. It's not a claim for damages in the prayer, according to the judgment. Ditto pleading in the Dre action. The bank claimed interest at the rate of 8% pursuant to the equitable jurisdiction of the court and or Section 35A and or Section 44. In the Christopher action, the bank claimed compound alternatively simple interest at the rate of 8% pursuant to the equitable jurisdiction of the court and or Section 35A. It's to be observed that in none of the actions is there any allegation of the use to which the monies paid away as the result of the defendant's fraud would have been put. Actually, we're one better than that, because Mr. Seaton does say, in terms, I would have used these sums in my business. And does say, I have been deprived of that opportunity in his evidence. Now, Mr. Stephen Smith QC took up the submission that I've made to your Lordship, which was that the pleadings, while not perfect, nevertheless were sufficient to entitle the bank to claim interest of damages. And that's rejected. But it's rejected on the basis that actually there's no assertion they would have done anything with it. I won't weary the board with it, but if one goes through the various pleadings of how the losses have been suffered, the losses are very specifically said to be the loss of the money. Loss one, if you like, in my four in these cases. And with a Russian bank, in the circumstances of these cases, it by no means follows in the way that it would have followed in Equitas and similar cases, that they would have used the money in their business or obtained something which could be usefully measured by the cost of borrowing. Banks sometimes take in deposits, but they don't often borrow from other banks at the rate of money unless they need overnight money for a particular reason, for example, to maintain capital adequacy or something like that. Of course, Equitas was not cited, and that's nobody's fault, because this case was decided on the 19th of April 2013, and Equitas wasn't decided until the 28th of October 2013. So it's a case on very different facts by a first instance judge looking carefully at the pleadings in his case and the circumstances of his case and deciding that in those cases what he's pleaded is not sufficient, and that there was not even the exiguous evidence of loss which there was in our case. As far as F&T Terex is concerned, again, the facts are entirely different from ours. It's not a case of a businessman having lost his money. As the citations in paragraph 80 make clear, His Honour Judge Stephen Davis looked at the facts and was by no means certain on the facts that there has actually been any loss. Of the kind that will be readily compensated by interest at a borrowing rate. And interestingly, though Mr. Justice Stuart Smith's citation of the principles from Equitas is referred to there, he distinguishes it on the facts of his case. Doesn't say that actually those principles are wrong or in any way inappropriate. I come back to the point that I'm actually defending a first instance decision in which the judge said, in the paragraph that I showed you the court this morning, Mr. Seaton is entitled to be compensated for being kept out of his money by an award of interest at a commercial rate. And in the circumstances in which the judge said that, plainly a commercial rate which is higher than the rate payable on the deposits, because the relevant paragraph of the judgment refers to the fact that he's entitled to it even whether he's actually got interest credited on the accounts. It's
around paragraph 80, I think.
Yes, I'm grateful. So, unless it wasn't open to Mr. Justice Sykes to make that finding, that the pleadings did actually say, I've suffered a loss, because I haven't been able to use the money in my business. And the evidence said I would have used the money in my business. And on that basis, to make an award at a conventional rate of borrowing, there having been the opportunity on both sides to put in evidence as to the relevant interest rates, and effectively to give practical compensation by making an award of it compound interest, then the Court of Appeal of Jamaica simply should not have set it aside. In so doing, we say they took a far too narrow view of what SEMPRA requires, and felt themselves compelled as a matter of law to say interest simply wasn't available. And in doing so, we say they erred, and the board should correct it. Would you, the board, give me a moment just to check that I haven't missed anything? Unless I can assist the board further.
Could I just raise a couple of small points? Your claim 2 is for an award of contractual interest on a compound basis, on the basis of a breach of contract, a breach of a contractual term. Section 3, of course, of the Miscellaneous Provision Act has no impact on that at all. And in any event, Section 3, if I understand it correctly, only applies to an ability to award interest from the date the cause of action accrued to the date of judgment. Right. So if the arbitrator, if the account makes an award in your client's favour, the registrar or indeed a judge wouldn't have any jurisdiction under Section 3 to make an award of interest under Section 3 post-judgment.
No, Lord.
That would depend upon the judgment rate of interest in Jamaica.
Absolutely.
Right. Do we know that?
Lord, I'm sorry, I don't have it at my fingertips.
And the second
I
thing...
could inquire behind me. Do you know what the interest rate is in Jamaica? I'm told it's 6% on Jamaican dollars.
Yeah.
Can I just add 6% on Jamaican, 3% on other currencies?
Well, Lord, I'm grateful to my learned friend. As I say, I have no material to do more than pass on my instructions.
Right. And then secondly, in the taking of an account, obviously it's for the registrar to give directions, but it might have been helpful for the appellant to set out what it proposes ought to be the account that the registrar should adopt.
My Lord, yes. We asked generally, going back to the hearing before Mr. Justice Sykes,
yes,
we asked generally for an account and explained why we wanted the account. But we didn't put forward a specific pleading in relation to that. If the board thought it appropriate, it would be open to the board to direct that the account should be taken, and then for the registrar, if necessary, to seek the equivalent of pleadings, as it were, as to in order to define the issues that the registrar, whichever judicial officer is going to take the account, would need to resolve, if any. I mean, it's not unknown in this jurisdiction in accounts for masters in the Chancery Division to do that sort of thing. I've certainly been party to an account on that basis where you've been required to exchange submissions so that everyone knows what the matter's in issue and what the court has to decide at the accounting stage.
Perhaps make an order that an application be made to the master, to the registrar within a certain period of time.
Lord, indeed. Lord, indeed.
And you're content with the registrar, is that right?
Lord, those are my instructions.
Yes, that's fine. Thank you very much.
Lord, if there are things to decide which are matters of judicial decision as opposed to matters of mathematics and calculation, it is probably better to have those decided by a judicial official. In this jurisdiction, I don't know whether in Jamaica the matters of calculation could perhaps be referred to a referee of some kind, an agreed accountant or whatever else to give effect to whatever principles are then decided as a matter of mathematics, which is simply a matter of crunching in the computer. Or the parties can agree. If you know the principles, then and the rest is mathematics. No doubt the parties can crunch the sums on their computers as well as everybody else.
Thank you very much, Mr. Salter. Before we adjourn, the court is going to rise for a moment just to discuss briefly the question of how we think the matter might go forward, the sort of matters that Lord Stephen's been raising with you. We will rise briefly and then return. board is grateful to council for this our short absence. We've taken the opportunity to discuss how we think we should go forward, and that is to request both council to prepare for the board an indication of the kind of order they would want us to make. Mr. Salter, in your case, it would be, if we were for you, that you were entitled to the 4 heads which you claim, i.e. including the loss of use and borrowing, and also, if we were against you on that, but with you on heads 1 and 2, which is the reconstitution of the account. Mr. Hilton, I'd be interested in your views on that exercise, and I would ask you to consider what order should be made if we were with you on the separability of the 9.2 million. I'm not sure how far you're pushing that in the absence of an estoppel, but if you are pushing that argument, but in any event, what order would be made if we were to order the reconstitution of the account? And that would include an indication for the registrar of when the account would start and when it would end. And I think it's agreed that it is an account in US dollars, a deposit account in US dollars, and I think we're agreed that insofar as there's no evidence of the contractual rate, that I hope parties can agree what an appropriate proxy for that would be. It seems to me that the average rates would be the appropriate mechanism. But if you were able to produce such guidance for us in the next 14 days, that would be greatly appreciated.
Certainly.
Certainly, my lord.
Thank you very much. Well, and Lord Stevens makes a very good suggestion. If it were possible for you to agree the actual interest rates in the absence of evidence from the average, which would be given to the registrar for the accounting exercise, that would make the registrar's task that bit easier.
Lord, I'm instructed that we're very happy to make that attempt.
Yes.
And so will we, ma'am.
Thank you very much. Well, the board is very grateful to council for their submissions in this interesting case, and also to those who have assisted council in the preparation of the papers and the preparation of the written case. The board will take time to consider what advice they will humbly tender to Her Majesty, and the board will now adjourn.